You weren't wearing a seatbelt. Does that mean you lose? It's one of the first things people panic about after a crash. They replay the moment. They think about what they could have done differently, and then fear sets in. Is this my fault now? Did I ruin my case? Can the insurance company use that against me? Hi, I'm Brandon Osterbind, and I'm a personal injury lawyer here in Virginia. We make videos to help injured people understand Virginia law. If these videos are helpful, do me a big favor and like this video and subscribe to our page. My team has helped hundreds of people in situations just like these. If you're worried about your potential case, don't be. I'm going to explain exactly what Virginia law says about seatbelts because the answer surprises most people. Let's start with what people assume. Virginia is a pure contributory negligence state. That means even if you are 1% at fault for causing the crash, you could be barred from recovering anything. So naturally, people think if I wasn't wearing a seatbelt, I must be at fault. But here's the key distinction. Not wearing a seatbelt does not cause a crash. You may ask yourself why. That doesn't make any sense. Well, it does when the law gives you clear rules. Here's what Virginia law has to say about seatbelts and accidents. Under Virginia Code Section 46.2-1094, the failure to wear a seatbelt cannot be considered negligence, it cannot be considered contributory negligence, and it cannot be admitted into evidence in a civil action for personal injuries. Here's what the statute actually says. Subparagraph D says a violation of this section shall not constitute negligence, be considered in mitigation of damages of whatever nature, be admissible in evidence, or be the subject of comment by counsel in any action for the recovery of damages arising out of the operation, ownership, or maintenance of a motor vehicle, nor shall anything in this section change any existing law, rule, or procedure pertaining to any such civil action. In plain English, insurance companies are not allowed to reduce your recovery because you weren't wearing a seatbelt. That is the law. Now here's where things get a little bit more nuanced. Even though the statute prevents seatbelt evidence from being used to prove negligence or reduce damages in court, insurance companies still ask about it. Why? Because they're not just thinking about a trial. They're thinking about leverage. Their mind is purely focused on how they can convince you that they don't owe you as much money as they do. You want to know the worst part? They're really good at it, especially when a lawyer is not involved. They may suggest your injuries would have been less severe. They may imply you contributed to your own harm. They may introduce doubt early in the claim process. And if you don't know what the law says, that doubt can change how you respond. You might downplay your injuries. You might delay treatment. You might feel defensive or even accept less than what your case is worth. But here's what actually matters in a Virginia personal injury case. Who caused the crash? What are your documented injuries? What does the medical evidence show? And how has the injury affected your ability to live and work a normal life? Don't get distracted by anything else. These are the questions that can actually impact how recovery, both physical and financial, will look. Seatbelt usage does not determine fault. And under Virginia Code Section 46.2-1094, it cannot be used in court to reduce your recovery. That doesn't mean it won't come up. It just means it's not the deciding factor. So if you've been in a crash and you weren't wearing a seatbelt, don't assume your case is over. The real question isn't what you forgot to do. The real question is, what does the evidence prove? If you're unsure where your case stands, give us a call. This is literally what we do. We separate fear from fact. I hope this video has been helpful. If you liked it, do me a favor and subscribe to our page. Before you go, make sure you watch our video, Minor Car Damage Does Not Mean Minor Injuries, because just like seatbelt assumptions, insurance companies often rely on appearances, not medical evidence, to undervalue real injuries.